religion, then, of every man must be left to the conviction and conscience of every man, of every man to exercise it as these may dictate. This right is in its nature an unalienable right. It is unalienable because the opinions of men, depending only on the evidence contemplated by their own minds, cannot follow the dictates of other men. That is just such a beautiful encapsulation of the Enlightenment philosophy, and that's why Madison later went on to say that the rights of conscience and opinion must be equally and completely exempted from government regulation, and that is why the final text of the First Amendment says that Congress shall make no law respecting the freedom of speech, religion, press, assembly, or petition.
So, that's the rundown of the First Amendment. The framers of the Constitution thought that our opinions and beliefs are the product of reason, and the government cannot force or compel our opinions and beliefs in any way. They are ours, and we have the right to them, even if they're unpopular. The framers thought that we as individuals have the freedom to think, to worship, to believe, and we also have the freedom to express our opinions and beliefs, unless those opinions are intended to and likely to cause imminent violence. Every right in the Constitution has a story behind it, and one big theme that emerges from these stories is that although these rights may seem so evident and unalienable, they haven't always been protected. Instead, we've had to fight for them. Did you know that our country has jailed abolitionists and religious minorities? It has tried to ban blasphemy and other forms of peaceful protest. And they've even suspended students for refusing to say the Pledge of Allegiance. For the first story, though, we have to rewind to the colonial period, before we were even a country, to talk about this interesting guy named John Peter Zenger. This is where the story of free speech begins for the Constitution.
In the 1730s, Zenger published an article criticizing the royal governor of New York for removing the Chief Justice of New York after the judge decided a case against the governor. This is core political speech criticizing the governor. But Zenger was tried for seditious libel. Seditious libel meant criticizing the government, and under the British common law at the time, truth was no defense. In fact, the greater the truth, the worse the offense. But Zenger's lawyer argued that true statements couldn't be punished, and a jury agreed and engaged in jury nullification. In other words, refusing to convict a guilty defendant because the jurors thought that the underlying law was unjust. And the case was so galvanizing that it came to stand for a core principle of the First Amendment, namely that true statements cannot be punished. Of course, there are circumstances where speech can be limited. The Supreme Court has said that speech doesn't stop at the schoolhouse gate. A case called Tinker held that a student, Mary Beth Tinker, could wear a black armband protesting the Vietnam War because it didn't materially interfere with school discipline. But another case called Hazelwood said that speech can be banned if it's inconsistent with the school's educational mission. When it comes to adults, the standards are even more protective. A case called Brandenburg from 1969 said that for adults, speech can only be banned if it's intended to and likely to cause imminent violence. That's because, as Justice Louis Brandeis said in a beautiful concurring opinion in the Whitney case, as long as there's time enough for deliberation, the best response to evil counsels is good ones. The best response to hate speech is counter-speech. That makes the U.S. the most speech-protective country in the world.
So Jeff told us about a few cases, but there are so many more. So many cases that the courts have taken up to help define our five freedoms. Want to know more? Check out the Constitution Center's interactive Constitution website to dig into the stories behind these freedoms, to explore the evolution of the text, to understand the founders' visions and protecting them, and most importantly, to understand how these rights affect us today.
You know, in some respects, it's a funny grab bag of rights that are in the First Amendment. It says it protects speech, it also protects religion and religious exercise, protects petitioning and assembly. You know, if you look at all of them together, what it says is that we are committed as a country to freedom of thought and conscience. And why are we committed as a country to that? You know, it was expressing some view that reason and thought was supposed to guide our culture, as contrasted with passion or violence. That there was a deliberative element at the very core of our being as a nation. A deliberative element that is reflected when one speaks, when one exercises one's own religion, engages in religious belief, expression, petitions, sermons, all of these things are suggestive of a nation that values freedom of conscience, that values reason and deliberation in making its decisions.
So the five freedoms of the First Amendment, religion, speech, press, assembly, and petition, are essential to the core of American democracy. Citizens and Supreme Court justices continue to debate the meaning of these freedoms today. Can a principal punish you for criticizing her on social media? Can the government regulate your use of violent video games? Or can a public university disinvite a controversial speaker? Let's ask Jeff.
There are good arguments on all sides of these hard constitutional questions. But in deciding them, I want you to separate your political from your constitutional views. In other words, let's ask not what you think the government in each case should do, but what you think the First Amendment allows it to do. The government cannot force you to attend church. It can't dictate which clergy a religion should choose. And most important of all, the government cannot ban hate speech or any kind of speech unless it's intended to and likely to cause imminent violence.
Every right in the Constitution has a story behind it, and it's a story told by the perspective of we the people. For the First Amendment, there's one big theme. When we think that these rights are self-evident and inalienable, they haven't always been protected, and it's up to us to fight for them. How will you use the First Amendment?
So it wasn't just the official establishment church. There was a broader principle behind it, which is that the government couldn't in any way prefer one religion to another.
Actually, there are two religion clauses. The Establishment Clause, which prohibits the government from establishing or creating a religion in any way. That's why we don't have an official religion in the United States. And the Free Exercise Clause, which gives us all the right to worship God or not as we choose. That means the government cannot penalize you because of your religious beliefs, or because you don't belong to a church or believe in God. Together, these freedoms make up the foundation of our freedom of conscience. That protects our complete freedom of thought and opinion, and the freedom to worship or not as we please. But how do we know if the government has established a religion? How can we counteract the power of one group, usually the majority, to take away or curtail the rights of a religious minority? That question is at the heart of the First Amendment's protection of religious liberty, and remains one of the most hotly contested questions in constitutional law today. Let's talk to Jeff Rosen, President and CEO of the National Constitution Center, for a little more backstory.
To understand the First Amendment's religion clauses, let's rewind to the period before the American founding. Many of the earliest American settlers, facing religious oppression at home, crossed the Atlantic in search of religious freedom. The result was a new world defined by religious diversity. There were Puritans in New England, Quakers and Lutherans in Pennsylvania, Anglicans in the South, Roman Catholics in Maryland, Presbyterians throughout the Middle Colonies, and there were Jewish congregations from Newport, Rhode Island to Savannah, Georgia. At the same time, many colonies had government-established churches. Colonial governments appointed clergy. Colonists had to pay religious taxes. Some were forced to attend church, and dissenters could be punished for preaching without a government license. James Madison in the First Congress drafted the First Amendment with this history in mind. Now, the original Constitution itself protects religious liberty. Article 6 bans religious tests for federal office. But the Anti-Federalists, those are the folks who opposed ratification of the Constitution, wanted more. They wanted to ensure that religious liberty, which was among the most widely protected rights of state bills of rights, was also protected in the new Constitution. Now, consistent with America's religious diversity, the First Amendment was designed to protect the right of individual believers to worship God as they pleased according to the dictates of conscience. The amendment also prevented Congress from establishing a national church or from disestablishing state churches. The amendment didn't reach state abuses until after the ratification of the 14th Amendment, which applied the Bill of Rights against the states. Nevertheless, all states had disestablished their churches by 1833. And the Supreme Court finally began applying the First Amendment's religion protections against state abuses in the 1940s, guarding the free exercise rights of individuals and preventing the mingling of government and religion.
Let's break down these two religion clauses and see how they affect us today. Let's start with the Establishment Clause. Congress shall make no law respecting an establishment of religion. The framers of the Constitution and others were worried about the federal government's overreach, so they wrote into the Constitution a way to stop the federal government from designating a national church. However, at the same time, there were states that had official state churches. For example, Connecticut's official religion until 1818 was Congregationalism. The Supreme Court today has interpreted the Establishment Clause to address issues that are important to many people in their everyday lives. For example, the government can't force you to attend church. Your parents might, but not the government. The government can't grant benefits to some religious groups and not others without a legitimate non-religious justification. The government cannot interfere in any way with the church's selection of clergy or its religious doctrine. Many issues that arise today are often hotly contested, but let's find out how the Supreme Court approaches these cases.
Usually, Establishment Clause cases come to the court and somebody is protesting that some kind of government policy favors one religion over another. Not in that strict sense of establishment, just in terms of preferential treatment. So, for example, suppose that there was a school that indicated that a certain kind of prayer was said. There were students in school who thought that's not the prayer that's accepted by my religion. Those students could come in and raise an Establishment Clause claim, and the court would sure this right now.
There's a legal test the court has traditionally applied to these cases, and it's called the Lemon Test, named after a 1971 case. To pass this test, a law has to do three things. First, it has to have a secular legislative purpose. Second, its primary effect has to neither advance nor inhibit religion. And third, the law can't cause an excessive entanglement between government and religion. Now, many Supreme Court justices have vigorously criticized this test, but the court has never overruled it.
Let's take the Establishment Clause cases and put them into four main groupings: government funding, government-sponsored prayer, government accommodations for dissenters, and religious symbols on government property. Let's ask Jeff to give us a quick rundown of all four case groupings.
Government funding cases involve challenges to activities that are carried out by religious organizations that receive public funds, most often and most importantly, schools. Scholars have often divided in these cases. One set of scholars says that the government has to be neutral between religious and non-religious institutions. The other set of scholars says that no taxpayer funds should be given to religious institutions if they might be used to support religion or communicate religious doctrine. Government-sponsored prayer cases involve prayer in public institutions, most notably public schools. This is probably the most famous set of cases under the Establishment Clause. And it begins with two cases, Engel versus Vitale, and the Abingdon School District versus Shem. These decisions struck down school prayer in the early 1960s. And while they got a lot of public backlash, the court has stood its ground, and it's even extended restrictions to prayer at graduation ceremonies and at football games. At the same time, the court has allowed prayer in government settings involving adults, like legislative sessions and town council meetings. Government accommodation for dissenters cases involve when the government grants some special exemption to a church or religious organization. For example, the military draft exemption. And then someone goes to court to challenge the exemption as unconstitutionally promoting religion. Religious symbols on government property cases involve public displays of religion. These are cases involving the displays of the Ten Commandments, or nativity scenes, or crosses on public land. They remain controversial. The court's main approach is called the endorsement test, and that asks the question of whether a reasonable observer would regard the display as a government endorsement of religion. The results in these cases have varied. The court sometimes upholds the displays and sometimes it strikes them down.
So keep an eye out on Supreme Court cases each year. You'll see these cases coming to the courts and find out where the court sits on the Establishment Clause.